Everybody, we'll give everybody a few minutes to jump in here. We already had a couple people, or one person drop out. We'll have some more people jump in here. We'll let them. All right, everybody, I'm going to go ahead and get started. It's 10:02. I expect there'll be more people trickling in only because I sent out the notice so late in the week because that's when I got the order from Judge Summers. Can somebody signal that they're able to hear me?
Yeah, I can hear you, Joe.
All right, thanks, Russell. Appreciate it. All right, and I've got a hand in the air from Karen. Um, I've got to let everybody in who's here. Karen Kirkpatrick, do you have a question? Maybe not. Um, I don't know did I accidentally disable cameras for people or did they?
Yes, because I don't have the option on my end to
Yeah,
show video.
I had then, and Russell, I appreciate you telling me that. I had an ongoing, a repeated webinar going, and unbeknownst to me, I didn't catch that it had, why we went a couple of weeks without one is I didn't catch the fact that they ran out. They don't run out of inventory. I had set them to keep going for I forget how many weeks or months, and they ran their course. So I had to start a new one. I can go into the, the settings and allow people to do that. I can do that in my Zoom right here. And look at this webinar. It says host and panelists are on, but it doesn't have a setting for attendees. Uh, hmm. All right. Well, I've seen most of your faces before, and you guys can all see mine, is my assumption. So um, I'm going to make sure that I've let everybody in who's in, and as other people come in, I'll make sure they're able to join. The other thing is I'm gonna send this video out as an email. This is one of the more important meetings that we've had of late. So let me just get everybody up to speed, and I'll kick it off by saying good morning. Happy holidays for those who are getting ready to celebrate the holidays. I'm Joe Whitcomb, founder and president of Whitcomb Selinsky, and lead counsel on this group's case against the United States government for primarily, misclassification, overtime theft, and wage theft. Now, on at 5:11 Eastern time, Friday, Judge Summers issued an order um, dismissing in part and denying in part, or granting in part and denying in part, the government's motion to dismiss a bunch of plaintiffs. I will start this conversation out knowing that it's being recorded and tell you that I don't agree with literally any part of the judge's decision. The he did an analysis on what a term you guys have heard me use before called equitable tolling. Before I get too far into that, I'm going to explain what equitable tolling is and why we care about it. So, a False Labor Standards Act case typically has 3 years that you can go back from the date that you file the claim. So, if you file it today, you could theoretically go back to December 21st, 2022. We filed our original claim, Lambro versus the United States, in January of 2021. So theoretically, that would have opened the door for everybody to go who was in that case, or at least for the people who initially filed, to go back to 20 to January of 2018. As I think most of you know, Judge Summers dismissed that case with prejudice, and we took it up to the Court of Appeals, to the Court of Appeals Federal Circuit. The government's argument then, and I don't want to belabor this too much because most of you have heard me talk about it. The government's argument and the motion that the court granted is, in order for anyone to be protected by overtime rights and minimum wage rights under the Fair Labor Standards Act, they have to be an appointee appointed to work for the government. What's happened unfortunately in this instance is that this Judge Summers, thinks or believes that misclassification is the actual cause of action. It's not. It's an overtime and minimum wage theft case, pure and simple. The reason we argued misclassification in the first instance is because we had to prove first that the plaintiffs, you guys, had rights under the Fair Labor Standards Act, that you were in fact not just independent contractors, but that you were actual employees of the government and were entitled to minimum wage and overtime. We succeeded on that with the Lambro appeal. So when that case came back, I immediately, within days of it coming back to the circuit court, down to the Court of Federal Claims, I filed a motion to amend that Lambro complaint to add 8 named new plaintiffs in 8 different agencies. The court to this day has never ruled on that motion. Instead, the court sort of scolded me for filing that motion and argued that I owed the court. The court had ordered me to work. Had ordered both parties to come up with a schedule or in which it was going to outline, in which the parties outlined discovery and so forth. Now, the order did not say only do that. The order said do that and do that by, and this was a June 13th, 2024 order. That order required that we do this status conference, this joint scheduling or proposed scheduling order by the end of July, by July 31st, 2024. But on July, call it 17th, 18th, maybe 19th, I don't know. It was June. It was either the day before or the day after Juneteenth. So it was either June 17th or June, I think Juneteenth or June 18th. So I filed that then, the amended complaint. The court didn't rule on the motion to amend. It just said, yeah, June 19th. So it must be June 18th that I filed it. So the court just simply just said, hey, I told you guys to do this order, or to do this motion. So we started doing that, and I went out and separately filed this complaint, this Jordan complaint, in July of 2024. And that's the case that is current. Both cases are currently active. The Lambro case, the 2021 case, only has Jason Lambro in it. The Jordan case has 250 of you in it, right? The 8 named plaintiffs, two of the named plaintiffs that related to Voice of America were Jordan and Green. And we added Lambro for the idea of retaliation. We argued retaliation on other parts. Well, the court ruled that Jordan and Green's statute of limitations had run because it had been more than 3 years since they were moved into PCS or PSC status. I responded. That was the government's motion. The government's motion was like, hey, Jordan and Green are outside the statute of limitations because it's been more than 3 years since the fall of 2020 when they were moved into personal services contracts, PSC status. My response was, moving them into personal service status did not end the fact that the government wasn't paying them overtime and minimum wage. It just changed their access, the way they were entitled to the benefits. I wrote that in my response to the government, and I pled that adequately in our original pleading. But I also reminded the court of that in our response to the government's motion to dismiss. I said, hey, look, Jordan and Green are still being shorted overtime minimum wage. I'm not even 100% certain that I was right on either, or that the government was right in asserting that both Green and Jordan were moved into PSC status. That was just their argument, that their assertion that hasn't been proven or disproven is that VOA moved everybody into PSC status as of September of of 2020. I don't know that that's true. I haven't assumed that that was true, and I don't care if it's true because people are still being. I've gotten a lot of indications since this case has been back, and we've talked to hundreds of you, that many of you are still being denied minimum wage and Social Security. But at the end of the day, the court ruled that Russell Green and Michael Jordan's cases were dismissed because they were the statute of limitations had run. Now he has dismissed those claims with prejudice, but under Rule 54B. Under the Federal Rules of Civil Procedure 54B, if those claims are dismissed, I can take them up straight to the Court of Appeals, which is what I plan to do. I plan to take those claims straight up to the Court of Appeals. Now, there's two other claims that the court dismissed with prejudice, that have nothing to do with VOA. Well, one is Lambro. He dismissed his claim for retaliation, saying that the court did not have subject matter jurisdiction over retaliation, and I expected he was going to order that way, and that opens the door for me to go up, and that opens the door for me to go in to the Court of Appeals and argue the issue that I wanted to argue, which is that the Fair Labor Standards Act was amended in 1977 in a way that moots the earlier court's rulings that retaliation is a claim originating in tort. So Jason's is going up on retaliation on that front. And with that, I'll also get to bring in one of the other claims from the first case. But second, who's also in this case as an opt-in. Then he went through and dismissed Marie's claim and Burke's claim, who work for different agencies on basically the idea that these were they're on issue preclusion, saying that these issues under the FLSA were already adjudicated in other courts. They were not. I've explained to the court 6 ways from Sunday how they were not, but we're going to get to take that up on appeal and deal with that as well, and that will help a bunch of other agencies. And as it relates to the folks of you who are on here, and I'm running out, my voice is running out, but those of you on here for Social Security, the claims that he kept alive were the justices' claims. Those are the folks that work for the Social Security Administration. I know Ms. Beasley is on that list. I know many of you are on that list. The Social Security claims, he said, you can keep those alive. Those are claims that relate back to the fact that the government has been shorting you guys under the joint employer, and that's a very good outcome for this case because that opens the door for joint employer claims. And so joint employer claims and putative employer claims means I work for ABC Inc., who is a contractor with the federal government, but I'm not getting paid overtime through that ABC Inc. because the government isn't paying ABC Inc. enough money to pay me overtime. So that's called a constructive violation of the Fair Labor Standards Act, and that opens the door for me to go and get all of that money as well, or go take that up on appeal and get revisions on. And that's what. So I want everybody to understand that as early as next week, I'll be filing an appeal on the claims that the court dismissed. As it relates to the Social Security claims, the court's invited me to file an amended complaint and add additional named plaintiffs if I so choose, or whatever, and amend that complaint. And I'm also going to, articulate, I think I've already articulated clearly because the court's really focused on the $5 cancellation fee, but I believe there's much more at stake than that. There's a lot of overtime and minimum wage stuff for people who are sitting around not getting paid at all while they're waiting on hearings to happen. And my argument is that is not the responsibility of the hearing recorder to worry about when the hearing kicks off. If they're sitting there, they should be getting paid. If they're in the building, they should be getting paid. And my argument will be, even if they're traveling on the way to the building, they should be getting paid something. If you're traveling to a remote location, the case law is pretty clear. If you're driving from your house to a normal place of business every day at commute distance, you don't get paid travel for that. But if you're being forced to leave and travel, like some of the folks here in Colorado live in Denver and they're doing hearings down in Pueblo, that commute to Pueblo is compensable. You should be getting paid rates for that. And I've already articulated that they were not. So we're going to get all of that's going to be repled. The claims that have been dismissed relate to, and I'm going to find the case here. I'm trying to get down to this. Friday. It was Friday, 3/11 my time, and it took me a while to read it and digest it. But yeah, the court is dismissing Lambro and Burke for lack of subject matter jurisdiction. Jordan and Greens were dismissed as time barred. Marie Ruberinda's claim, failure to state a claim upon which, and the court defers on Sue and Steve Justice. And so those are the ones I'll be taking up on appeal. I don't know that he's dealt with all the named plaintiffs, actually, and that's something else that I can bring up. He is charged with dealing with all the named plaintiffs, but he has not dealt with all of those. So, but all that to say that I'm going to be filing an appeal. I'm also going to be filing an amended complaint, all within the next days or weeks. The outcome that I am anticipating, and this is why I'm a little bit. I would have been happy if the court had done it right the first time, but I expected even if the court did do it right the first time, then the government would be the one ready to file an appeal. Because we're going to be the one driving the train on the appeal, we'll be able to go up, and if I get the outcome I'm anticipating, ladies and gentlemen, I will get to argue, and hopefully the court will grant at least 6 years back. That's the goal, at least 6 years back from 2021. Going back 6 years from 2021 would put everybody at 2015. And that's always been the goal. Now there's this narrow sliver where I can get the Supreme Court to reverse prior precedent and get back to even further in time, forever in time, back to 2002. But even under current Supreme Court precedent, I ought to be able to get back to 2015. And that would open up the door for 10, 12 years of damages. Now that's sort of the silver lining and the bright outlook on this. The thing that is frustrating for me, and I'm expecting for you guys, is that it's taken us 18 months to get to where we are now. And that's been slow going. And obviously, I don't love that. I certainly don't love it for you guys. You guys have to, I don't know that you need reminding, but my firm's not generating any revenue on this case until we actually, get a win. But for you guys, you're sitting around waiting forever and ever for an outcome that is, in my mind, fairly obvious. And it feels unfortunate. Unfortunately, to me, it feels a little like we're taking on the United States government and we're taking on the court in a way that we shouldn't have to be fighting the court. The court should be more objective in my estimation, but that is not what's happening. So all that to know that I'll be turning that around in the next few days or weeks. And one of the things I'm gonna do when I amend the complaint is bring in some other named defendants or named plaintiffs for Voice of America, because I want to make sure that we've at least staked our claim on. We had when we first filed this back in June of 2024 or July of 2024, we had 8 named plaintiffs, and then we had probably another dozen or more, 13 or 14 opt-ins from the first day we filed it. So we can go back and grab some of those opt-ins, make them named plaintiffs. Their stakes should be claimed from them too. And just remind the court, hey, by the way, this is not just about being misclassified. Even when they moved everybody over to PSCs, they still continued the practice of not paying overtime. Many of you have told me stories where you went to go file for overtime and they told you to file for comp time instead, or they told you that if they required you to be on call, and one of you told me that if you didn't volunteer to be on call, you're going to be voluntold to be on call. So, and being forced to work weekends with no additional pay, no overtime, and allowed only to take comp pay. And many of you have heard me explain why comp pay is not an adequate substitute for overtime pay. So we'll get into all that. What I want to do now, I just saw Jordan just jumped in. He was one of the guys that was affected by this. I want to open the door to questions. We'll do like we've done in the past. If you have a question, just use the little hand in the bottom middle of your screen. Raise your hand and I'll call on you in the order which is what I call it. I know I said a lot, so if you have questions, don't be afraid to ask. All right, Karen, Russell. Russell Green's hand was up first.
All right. Basically, my question is, for those of us who would still like to submit additional documents, um, this is not just a question for me, it's also for others because the software can be um, difficult slightly at times. So if I want to, or if any of us wants to um, send multiple documents, just say a contract, and
Yeah,
the contract is like 15 pages. Um, will the Clio allow you to send the entire document versus going page by page? And the reason why I asked that question is because in the past, sometimes it's worked where I could just send a whole file by itself, and other times um, I had to send documents into the Clio one by one. So could you
sure.
advise us of how that
Yeah,
works?
very easily. So if you want to do multiple, I want to try to put the narrative in place. So it will upload large documents. Let's say you've got a 100-page PDF. It'll upload large documents, and it will only upload those one document at a time, unless if you've got a folder of documents that you want to be treated as one, just right. If you're using a Microsoft, or Windows based system, just right click that folder and compress it to a zip file. Then it will allow you to drop that entire zip file into that folder. Does that make sense?
Yes, yes. Now it does.
Now,
Yes.
I'm not as Mac smart. I'm talking to you on a Mac right now because I'm married to a Mac girl, but I'm
Uh-huh.
not as smart on Macs. So, but I believe there is a mechanism for doing that on Macs, similar to what I just said. It's probably like a command or a control key versus type of thing. But I know on a Microsoft, on a Windows based system, you can just right click the folder, compress it, and then it will treat that whole folder as one doc. Clio, I shouldn't say it. Clio will treat that whole folder as one document for the purpose of uploading. Now I'll have to export it and open up. That's fine. That's not your problem to solve. But for you, just zip that folder and it'll upload it as one document.
All right. Cool. Thanks, Joe.
Of course. All right. Who else we got? Hands up. Like I'm coaching basketball, um, and I could only coach basketball. Could never play it. Who's got a question? Michael Jordan. Speaking of.
So I think you have all my documents that you need. Do you need anything else from me
No,
or?
I don't. No, Michael, what I would like some clarification for some of you, and you could go into your portals and do this. There's been an assumption that, and this is an assumption that the government has advanced, not one that I have advanced, but one that the government has advanced, that VOA, and this relates to the USAGM VOA people on a call, not so much the Social Security people, but for some of the Social Security people, I want you to do a similar exercise, but I'll explain why. And there's multiple agencies, but the two biggest populations in this group right now are VOA and Social Security. Of the 250 folks or so that I've got in this case right now, about 90% of them, it's like 45% are VOA and Social Security, and the other 10% are all the other agencies combined, right? So, but what I want to say to you is, if you're in VOA, and there's being an assumption made by the government and by extension the court, not by me necessarily, that you are all properly. Don't get into the word properly. Don't dig too deep into that. From the government's perspective, you are all PSCs. I believe I know that is not true. I believe that I know a few of you are still 1099s with USAGM. I'm trying to help the court to understand that it doesn't matter. That's always been my argument. It doesn't matter. I anticipated the government's, the reason I talked so much about misclassification at the beginning is that I anticipated and headed off the government's defense that, hey, we don't have to pay them overtime or minimum wage because they're independent contractors. That part I've gotten over and we've won. But now the court's like, well, no, they're not independent contractors anymore. They're not being misclassified. Therefore, they're not being shorted overtime minimum wage. I would like you, any of you who are within the sound of my voice, who have current examples where you have asked for overtime and been told you couldn't, you had to take comp time or you weren't allowed to work, you weren't allowed to make overtime. to articulate that in your portal or let us know somehow. And then as it relates to Social Security folks, the SSA folks, if you're not you, Siri, Social Security folks. Siri thinks I'm talking to her. She's very vain. If you're working for another federal contractor, right? I don't want that. When I started this case a year and a half ago, that was the nut I wasn't certain I was going to be able to crack, but we cracked that, even in this order. The court has bought the idea that the government can still be responsible for shorting you overtime, even if you work for another government contractor. So if you work for another government, like in the Social Security universe, you guys know I know this, but it's like Carmazzi, it could look like Ace, it could look like Stratton, not Stratton, Stratcom, whatever it is. I know with VOA, it could look like some of you are working for what is the Jason was here, he'd spit it out right away. TechniArts was one of them. So there's a bunch of contractors out there, but those folks are really nothing more. And this is the argument I made to the court, and the court seems to have bought this. Those folks are really nothing more than pawns. The government goes to them and says, "Hey, we want somebody to work 2,000 hours a year. You bid it at 2,000 hours a year." And when the contractor, and when the individual worker ends up having to work 2,100 hours a year, the government makes that the contractor's problem. And most times the contractors don't have any money to pay that time and a half, or even the money over 2,000 hours, because that's all they bid is 2,000 hours. Some of them have enough cushion in their bid to float it, but most do not, because as you guys all know, in the government contracting universe, that's a race to the bottom. It's lowest price offer normally wins. All right, so I had another hand in the air. I wanted to get around to that. The hand went back down as quickly as it went up.
Hi, Joe. That was me.
Denise?
I had a question. So the last time you did your webinar, I had mentioned that they recently changed our badges to PSC to contractors, and I'm not sure what that's about, but do you have any idea of why they would try something like that?
Besides they're just absolutely losing their mind, I would be, Lenny, if they have changed your pay in any way, I absolutely want to know about it. If they're still paying you as a W-2, then they're probably hanging the title contractor on you, because they're trying to, more or less segregate you into a bucket of non-employee, non-GS employees or non-W-2 employees. But if they change your pay and they start paying you as 1099s again, I definitely want to know about that.
Okay. Yeah, because the pay hasn't changed, and we're still doing we still have a W-2. So
Okay.
I'm assuming I'm hoping that
it's just about
after this.
language then. Yeah, it's just about language. But listen, I'm as serious as a Billy Joel heart attack. If you guys learn about, if you guys, work over 40 hours today, tomorrow, next week, if it's an ongoing where you work over 40 hours and they try to get you to take comp time instead of paying you time and a half, I want to know about it. And I want to know as much about the conversation that you had with your supervisors as you can remember. So, and you can just go to your individual portals and report that. If you send it to me in an email, that's not the end of the world. I'm just going to move it into your portal so we can keep it in one place. I'm going to have my paralegals reduce that stuff into affidavits.
Okay, thanks.
No worries, of course. Thank you for the question. Anybody else have any other questions? So guys, look, Judge Summers just created a bunch of work for me. Again, this is kind of the path that I expected to be on. I told everybody more than once, I'll probably have to make more than one trip to the Court of Appeals. That motivates me even more to go back and do my Form 95 filings, because that's another way where I can at least get these complaints into other courts about state-based claims. That's a very heavy lift, because you've got 50 states and territories and all different employment laws in those states, and they all have to be pled differently. And I'm kind of a one-man band. At least I have, a firm of 30 people, but I'm kind of one deep on this particular call it intellectual exercise of how to prosecute this claim going forward. And it sounds like I'm beating my own drum here, but I'm kind of I'm kind of a one deep individual and knows how to prosecute this claim. I bring in help when I need it, and I ask for other attorneys' help when I ask for it. But this is kind of my own invention, and not very many people have I been able. I've gotten Matthew. He's getting the concepts, but he'd be the first one to tell you that he over at Forrester Haney. He'd be the first one to tell you that suing the government is not their kettle of is not their cup of tea. Suing the government is how I basically built my law firm for 14 years. This is just an unusual case within that subset of suing the government. So this Court of Appeals case is going to go up right away. I'm going to try to, again, the goal is going to eventually get all the cases united under the umbrella of the Lambro 2021 claim, and then, reach back as far as I can in perpetuity for everybody involved in this case. So that's what I'm after. I'm sorry that I had to throw together such a quick meeting. I will take this video and I will absolutely post it on our website, and I'll send out the link to you should here. The link to the website is in all of my emails. The website is the US Gov OT Rights. I'll drop it in here again. I'll drop it in this chat for everybody's benefit. Again, I'm going to put this for everybody. I always forget to do that. That's where, and if you go to the resources page, it's called information sessions. That's where I put the webinars. If you go down, if you scroll down to the bottom of the page, there's like 4 or 6 of me in there. I'll just keep adding to them. I'll get this one added when we're done. They're clunky and clumsy and me talking nonstop, but there's some useful information in there. Does anybody else have any questions before they go watch the Bills beat up on their enemies? If you guys haven't heard me talk about this, we're Bills fans here because the boss lady grew up in Buffalo. So now we've got an internal fighting going on because we also happen to be sitting here in Denver, and it could shape up to be a Denver Buffalo conference championship. So if I suddenly go missing, that'll be the reason. All joking aside, if the FBI is listening, I'm only joking. So listen, guys, I want to make sure this is, this kind of punched me in the gut. It's weird that it punched me in the gut because I was completely expecting Summers to do this. I fully expect, guys, I fully expect the Court of Appeals is going to rule in our favor the way in as spectacularly a way as it did the first time. In this instance, though, I think we'll get even more relief for more people by taking this case up on appeal. We'll be able to open the doors for even more. That's the good news. The bad news is, unless the government suddenly grows a brain and realizes that it realizes its own vulnerabilities, this is gonna drag out. Now, the government could step up any minute and try to offer a settlement, and if they did that, you guys would all have a voice in that settlement and what it looked like. So. We're a little bit of a waiting game right now, but I'll have this notice of appeal up in the amended complaint for the Social Security folks. But I'm going to file a separate motion to amend the complaint again and bring in other VOA people and other VOA people and other Social Security people, other agencies, period. All right, because the other agencies are still doing the bad things. And those agencies shouldn't be let off the hook on a pattern and practice case just because Judge Summers thinks that some of the people's claims have run. But other than that, I'll let you guys go. Do you guys have? I want to make sure I shut up long enough to let you guys ask any other questions you may have. I don't see any other hands. If there aren't any other questions, I wish you guys all a very happy holiday and New Year. However you guys are celebrating, whatever you're celebrating, I wish you all the best. And we will meet again after in 2026. That's what I expect.
All right. Thanks,
Okay.
Joe.
Thank you very much.
Thanks, Joe.
All right. Thanks, guys.
Happy New Year.
Happy New Year to you. Talk soon, guys.
All right, thanks, guys.
Miss Beasley, you had a question. I can hang on with you. If
Thank
you'd
you
like.
very much.
Take care now.
Okay, yeah, I do have a quick question.
Go ahead.
I heard what you were saying, so we need to submit some information too. You're gonna let us know what we need to submit, or
So yeah, I let me get into your case right now because I've got individual cases open for every person in this case, and I've even got the boss lady going through and making sure that everybody's got a portal open. And I think you know who I'm talking about when I say boss.
yes.
So she's been working from home for me and getting some stuff done and going through there and making sure that people. Hold on, let me get my password in here. But I'm going to just raise this to the top of your inbox again. What I'm looking for, Miss Beasley, is just any instances where you just think of it in the simplest terms possible, where you worked and didn't get paid. Either you worked overtime, didn't get paid time and a half, drove to a hearing. You're over at Social Security, right?
Correct.
Yeah, drove to a hearing, didn't get paid for the mileage, drove to the hearing got canceled, got paid $5 or didn't get paid at all, or they, any of that nonsense, right? I want to know about all of it. And what I want you to understand, a lot of people hear this and they're like, oh, well, I got to prove, you don't have to prove anything, right? I don't want you to lie to ever, but you don't worry about, well, I didn't take a picture of my odometer that day, or I didn't clock in that day, or I didn't sign. Don't worry about any of that. Worry about, here it is. I'm going to put you in this right now. You did not have this portal open. I don't know why. Let me find out something else too. Let me see if you should have it. I'm 99% certain you've signed an engagement letter with me. Yep, you do. Sign. Yep. You signed an engagement letter with me back in July of 24. So you've had an engagement letter a long time. I'm going to send you a client portal right now. And I'm going to, in that client portal, I'm going to give you a list of the things that I like to see.
And how far back do you want me to go?
As far as the court is trying to limit me now to 2021. I want you to go back as far as you can remember. Period.
Oh, okay.
Yeah, just go back as far as you can remember. I'm going to be tone deaf with this judge as far as him trying to limit my damages. I'm not worried about that. But as far as you're concerned, you go back as far as you can go back. I'm trying to close all this stuff down here. Snippets.
One thing I did do is keep all my emails and stuff from where they request you and stuff like that.
Lovely. All right, I'm going to send you this portal right now. And again, if anybody doesn't have a portal, you guys can let me know. The email, I just sent you a portal there, Ms. Beasley. You should be able to open that up, and I'll give you some instructions. I've got that pretty much standardized, but
Okay.
and yeah, you just go back as far as you can remember. You can't overwhelm me with information. Don't worry about it. Just put as much as you can remember.
Okay.
Yeah.
Sounds good. Thank you.
Of course, go ahead. Who else got a question?
This is Karen.
Hey, Karen.
I know I don't have a lot put in on my information. I worked for 2 companies at one time,
Yeah.
and
Are you over at Social Security also?
was a contractor.
Right, but I'm with SSA, right?
Karmazi and
Yeah, Kamazi and probably Ace or Stratcom, right?
Stratcom.
Yep, I know them well. I've handled both of their cases from when the government was coming down on them for not, again, this is that scheme I was telling you about. The government put those guys on lock, said this is all the money you get to pay your people, and then made you guys work way more than they paid the contractors. So I'm in your claim right now.
I know I don't have a lot in there. You need all of the $5.
Well, here's what. So that's an excellent question, Karen. I want you to understand. I do not need to at this stage. I do not need to articulate every instance in which you worked $5
Okay.
and got canceled. All I need at this stage is enough for the government to understand that that's what they're defending against. So we can say Karen worked many, many times for for these things, and the thing was canceled at $5, and worked 45, worked an hour, worked 2 hours, and paid $5. It would be really useful if let's say it happened 50 times in 5 years. If you gave me 3 examples of them happening, that's enough for me to get through the pleading stage.
Okay. I was working on collecting that app, and then I got sick, so I wasn't able to get it going again, but I will get that going again.
All right, I'm going to put this at the top. I'm putting this at the top of your inbox. Okay.
Okay, and then also I was the one that had the 30-something thousand, 3,000 something lack of pay from Karmazi when they filed bankruptcy.
And that's what we're putting at the government's feet. All of that is what we're going to put at the government's feet. And so if you have
And I have a letter from them too. I'm gonna send that over to you, where
I'll
they say, where they say that the government owed them, $250,000, and they hadn't been paid, and that's why they couldn't pay us. So I have that, but I also was contracting with the government prior to Kamazi basically taking over.
You're one of the many BPAs that they screwed over, and I'm going back for all of that. Now, when you were BPAs, you guys, most of you that I've heard talk, like Sue and those others, they had a better deal as a BPA than they did under these contracts by a long shot, is what I believe.
Yes.
But
well, I will say this, yes, but when Kamazi came, they pretty much was, to get everybody on board, they said, hey, we'll pay you the same amount that you were making before. And then, to get people working, and then we didn't get paid.
Then they got ran in, and they were just, Karmazi in there. Like I said, I represented those guys all the way up to the Court of Appeal, but they just ran. I actually inherited that case from another attorney, but that they just ran out of money because the government wouldn't pay them, and the government was doing them. They were extremely crappy to those guys, and it hurt you. So the Kamazis and the Aces and all that, these guys would submit invoices. The government would sit on those invoices for like a month and send them back and say, hey, you forgot to dot this I or cross this T.
And then they wouldn't know which one it was.
That's right. And they wouldn't know which one it was. Or they wouldn't even tell them that they failed to dot an I across the T. They would just say, these invoices are not compliant, fix them. And these guys they'd write them and say, well, what's not compliant? What do you need fixed? Basically, it's not our job to tell you that. Like, it's certainly their job. Yeah. So meanwhile, you guys are all sitting around languishing, waiting to get paid. And, it was all three. Now, Stratcom just got big enough that I think they were able to absorb a lot of that stuff. But Karmazi and Ace, they were not.
Before I left Stratcom, I was traveling all over the state of New Mexico. I live in the southeast corner, and they would pay me like $300 to go across the state to Farmington and work up there for my travel expenses.
Yeah, all of that, every single bit of that, you should articulate in your claim, because the one thing that my guys down at Forrester down in Dallas, they're really good at that part. One of their big claim to fame was a Domino's case where the drivers weren't getting paid for travel, and that's how they were able to get a lot of money for Domino's. But I definitely want to incorporate travel pay, overtime, minimum wage, all that stuff that you're not, because they got a choice. The government has a choice when you travel. They can either pay you by the hour, which would be more expensive for them, or
because it didn't pay for the time, because it was 7 to 8 hours travel time one way.
Yep. And I'm saying they didn't want to pay you for the travel time. So they don't want to pay you for the time, so they have to pay you for the travel.
Yep. Yep. They didn't want to do either. You
That's
you
right.
get
They
there,
don't
you
want to
might
do
not
either.
have any you might not have any work when you get there.
Yep. And
Of
I
course,
had
I took off the mileage out for my income tax. Does that have any effect on it?
it might if it has an effect, Karen, it might be something where your accountant has to end up doing an amended income tax return, and he can decide which way he or she can decide which way is best for you from an income tax perspective. But the government owes you the money. And I always tell people it's never a good idea to refuse money in order to avoid paying taxes. Take the
Yeah,
money and pay the taxes on it. My advice always.
right. Sounds good. That was my concern on that, since
Yep.
I did take the
There
expenses
won't
off.
be any penalty if you're worried about that because you didn't get the money yet. You just have to if it results in an increased um, uh, taxable income, you have to pay the taxes on the increase, but that's it.
Yeah, I'm not worried about that. I'm in such a low
Well,
income
I'm also,
income
by the way,
level now.
one
Now
of
I
the
don't
other
worry about
things I'm trying to put at the government's feet is your self-employment tax that most of you had to pay that you shouldn't have had to pay when you were
Yep, sure
Yeah.
did. And it was very expensive.
That's exactly 7.65% of your income. Denise, your hand is up again. Did you have a
Right.
question?
Okay, I'm here. I'm sorry, I had to step out the room because I'm at work.
No, you're great.
Question. So, when we came back from the shutdown, a lot of us contractors thought that we were going to get paid kind of immediately.
Right,
And we came back on a Thursday. The full timers got paid that Friday.
right.
And then there was a rumor buzzing around that the contractors may or may not get paid. They said they were working on it.
Right.
So, and I said, well, why aren't we getting paid? So, from what they explained to us, and this is just from us talking with other people, that at one point we were deemed essential and then now we're not. And they said they don't necessarily have to pay the contractors. So
Have
I
you
was,
bottom line, Lenise, have you been paid yet?
yes, we did get paid like a week ago.
Okay.
So,
Did it
but
bring you up?
I'm
Did it bring
concerned
you?
that if
Did it
there's
bring?
another shutdown, it could happen again and they may not pay us.
Well, there's definitely that is you're 100% right on that front. And I saw the president running around saber rattling about not paying air traffic controllers. I'm like, well, if you do that, you can expect some pretty miserable freaking holiday travel, right? But I think we certainly will want to bring that up when it comes to discovery as it relates to the ways in which you guys were treated like lesser employees than the other employees, right?
Right.
That could also be incorporated into your state-based claim under this classification. But right now, I'm just trying to get as many of you under the umbrella of the overtime and minimum wage stuff to claim that I can, because that's where I can get you, in my estimation, the most immediate money.
Okay. And I forgot how to get to the portal.
Lenise, let me just pull it up and put it back in it'd be in your inbox, but if you did a search for Clio, CLIO in your Outlook, if you're using Outlook, it'll come in there. But let me just go to my client portals here, and I'll just put it at the top of your portal again, or put it at the top of your inbox.
Okay.
Because when I hit send here, it'll go to the top of your inbox here. And it should be from Clio, CLIO. It's my case management software. Anybody else got any other questions?
I thank you for answering all mine.
Of course. No, you guys got me for an hour. So I want to make sure I'll give you some Sunday back if you want it, but I don't want you to feel hurried. Thomas, I know you just jumped on a minute ago. I don't know and Aisha, I know you guys kind of jumped in late. If you guys have any questions, I'm happy to answer those. I'll be posting the video. So if you didn't catch the beginning, don't worry. I'll circulate. It'll take because of an hour-long video, probably take a half an hour for it to hit my inbox, and then I'll circulate it again to everybody, and then I'll put it up on the website as well. So don't worry about anything you might have missed.
Okay. Hi, it's Thomas.
Hey, Thomas.
I was just looking at the email that you sent yesterday for this meeting,
Yes.
and it says something about the Judge Summers. I guess you probably went over this earlier, so I hope I'm
Yeah.
not.
I did, but again, I'm going to send a video out and it'll explain everything. I talked for 20 straight minutes, so get a coffee. And you'll be caught up on the end of that. And if it creates any questions, Thomas, you know that I'm going to put this portal at the top of your inbox too, so that you know that that's there,
Okay.
so that you can directly communicate with me and my staff and I, about anything related to this case.
Okay. Thank you.
Let me put this in client portals. I'll just put it at the top of your inbox so if it raises any question. I was going to send you a copy of the decision. I think that it would be just, first of all, it'd probably be demoralizing for many of you to read it. But I may just have my AI do a summary and post that, so that it's not so legalese and it won't be so difficult to digest. But in the meantime, like I said, I've covered the high water marks on this video, and I'll post that video on our website, on the government overtimes rights website. And if you have any questions, just do a search for Clio in your inbox, and that should have your access to the portal, and you can put whatever you want, any questions you have there.
Okay. Thanks, Joe.
Of course not.
Thanks.
All right, thank you. Anybody else?
Appreciate all your hard work on this stuff.
It's been about 5 years now. It'll be 5 years in January that we've been at this. It's like a career move, but it's a worthwhile career move. We have the potential to help. This case has the potential to help tens of thousands of people, and I'm happy to do that.
I never thought I'd ever see any of the money back.
Well, listen, Karen, you guys, I mean, if there was a silver lining in this cloud on Friday, was that the Social Security people looks like they get to. He looks like he still only wants to reach back to 2021, but that's one of the other things that I'm going to try to get that equitable tolling argument fought up at the Court of Appeals. The job is to get everybody open all the way back, at least as far back as 2015. That does a lot for everybody. If I can get if I can get it removed completely, I'll be okay with that too.
Yeah, well, I'm hoping you get it back farther than that, because mine goes back to 17. 16
No, I'm
is,
trying to get back to 2015. Okay.
yeah.
And again, I think there's a universe where I could go back to farther than that, but we'll figure that out. I'm trying to get the Court of Appeals to weigh down on it. That's what how I'll be spending January.
All
So
right.
you're gonna have a fun New Year's.
That's right. That's what January looks like. All right, ladies and gentlemen. Last thing I have to say is go Bills. Talk to you guys
All
soon.
right.
All right.
Bye.
Thanks, Joe.
Merry,
Joe,
Merry
All
thank
right.
you.
Thank you.
Thank you. Bye-bye.